So, good morning, John. How are you?
Morning, Sarah. I'm fine, thank you.
Good morning.
I'm fine.
Good morning, everybody, and welcome to our webinar on IP. And mine's Sarah Lavery from CPG and Startup Richmond. And we're absolutely delighted to have John with us here today. He's an absolute expert in everything to do with I suppose, IP, law, contracts. I mean, you've got a wealth of information, John, really, don't you?
Yes, in commercial law and technology law in particular.
Brilliant, fantastic. And I know there's a lot of you out there that have a lot of tech businesses, and I suppose might get a minefield is what IP really is. And it's there's a lot of information out there that can be quite complex. So we were delighted that John accepted our invitation to do a webinar and to basically demystify everything to do with IP. So what I'm going to do is I'm going to just hand it over to John now. What will happen is you'll see the presentation and a screen will pop up with John on it there. And just again, if you have questions, just email them on over. And a lot of you have already sent me some questions, so thank you for that. We will be posing those to John at the end of the presentation. And yeah, that's really it. Okay, John, over to you.
Thank you, Sarah.
Yes, my name is John Warchus. I am head of the commercial and technology law team at Blatch. Based here in Richmond, I also spend time in the city office. I have 4 or 5 colleagues who also work with me on commercial and technology matters, based between City, Richmond and Southampton. Blatch, for those of you who've never heard of us, is a large, medium-sized firm by today's standards, about 350 people, 50 partners, main offices, Southampton, City and Richmond. So I hope to explain some of the practical points of maximising value for your IP over the next few minutes, and be happy to follow up any further questions either via Sarai and Helen or direct. The contact details are on the presentation. So without further ado, let's move on. Yes, what is IP? It's probably worth spending a couple of minutes just trying to go through obviously what IP is and why it's important, really is more to the point. First off, of course, IP are a set of intangible rights and information which are of commercial value. If they didn't have the commercial value, I mean, we wouldn't be bothering talking about them here right now. As the name implies, property, they are forms of property, so they can be sold, licensed, traded, just as other forms of property can be. The difference is, of course, here is that they're mainly invisible and they're usually intangible. As any type of property, it's worth protecting. One of the confusions I know for lots of clients and lay people is that there are different IP rights, and the different rights have different rules, and so it can be quite complex. People talk about patents when they often mean trademarks, talk about trademarks when they really mean copyright. That's, I'm afraid, where you do sometimes need to have, expert professionals like ourselves, solicitors, or even patent trademark attorneys. Other key thing to bear in mind is that IP rights can either be registered or unregistered. Registered means, as its name suggests, you have to go through a form of formal registration. That normally means disclosing details or requesting a particular right or name, and there is some form of publication to the outside world and the ability for third parties to challenge the application. Unregistered rights arise automatically, or they arise just through use, so there's no formal registration process. Territoriality. You must remember that nearly all rights are national rather than international. One exception, I suppose, would be the EU trademark, commonly called the community trademark, which covers all of the EU. But generally, if you're talking about a patent right, you're talking about a patent right in one country or more. So you have to apply for most forms of registered IP in each country that you want protection. So being protected in the UK won't protect you in the US and vice versa. Costs. To some extent, costs can vary a lot from, for example, patents, where I know patent agents tell me to get a UK patent application to the formal registration will often cost up to £10,000, although it would be spread over a few years, to free, I suppose, forms of IP like copyright. Copyright arises automatically, and so there's no actual charge. Because the cost can vary, and also because of territorial rules, most businesses can't actually afford to actually register IP in all the countries where they may be trading. So there's an element of being strategic and trying to work out what your key markets are and registering there, getting protection in the key markets. Very important, talking generally about IP, to have an IP strategy, some sort of an IP plan. But bear in mind, of course, that IP is one of your tools, it's one of the business's assets, and the IP strategy should be part of the overall business strategy, business plan, and not the other way around. IP is a means to an end. It's usually not the end, an end in itself. And finally, the last few slides on this today, I notice a lot of people always ask questions about it, is if you have a company where a lot of the value is bound up in IP, what do you do on sale, or how do you get ready for selling your business? And in many ways, it's always a good idea to try to deal with IP, bearing in mind that ultimately your aim might be to actually sell the company at some point. So if you get into good habits at the beginning, it's going to be a lot easier to prepare for sale. Moving on to the different types of IP, very quickly, copyright is an unregistered right. That arises automatically out through the act of creation. And for example, literary copyright protects books, novels. Also, it's the legal way of protecting computer software. As I say, copyright will belong to the author, the party creating it, unless, of course, it's an employee in the course of its business, or it's a consultant where you have clear clauses stating the IP is owned by another party, typically the party that's commissioning the software being written. Trademarks are either names, logos, colours, and these days even smells. A trademark is really a badge of identity, trying to guarantee that certain goods or services come from a particular provider. Trademarks can be registered or unregistered. In fact, unregistered trademarks are really, what that means, we mean by that is basically if you use a particular name or logo in relation to goods or services over an amount of time, you may well have legal rights to stop other people using the identical or something very similar. That, as some of you may already know, is called the law of passing off. The only problem with passing off is you have to show you have a good reputation in the name or the logo to be able to enforce that right. Much easier and more straightforward if you actually have a registered trademark for a word or a logo, because then all you need to show is that someone else's mark is either identical to yours or confusingly similar. Patents protect novel ideas capable of being used industrially. They need to be new, need to be novel, and I think some people may already know, if anyone has done something very similar or the prior art is somewhere already known somewhere in the world, you can't get a patent in a particular country. So they do need to be new. Designs protect the outward appearance of products. So if the actual appearance of something is quite important, say something like the old Jif plastic lemon container, or say one of the Dyson Hoovers. So particularly in consumer markets, design rights can be of importance, of relevance, also certain decorative arts as well. Databases are the collections of related data. There is a specific database right, which may be able to protect a database of items. Also, where there is some reasonable degree of originality and creativity in putting together a database, it may also have copyright protection. These days, though, copyright in relation to databases has a slightly higher hurdle to meet than copyright in other areas. Last couple of things. Data, of course, a database is the collection of data, but as a whole, but individual bits of data, I mean software, is churning out more and more data. Sometimes there is an underlying commercial value in the actual data itself, irrespective and aside from who owns the database. Finally, confidential information. Traditional IP rules don't really protect confidential information, i.e. sensitive information, trade secrets or whatever, which are commercially valuable. The only real way, as you'll see a bit later, to protect that is by having non-disclosure agreements, confidentiality agreements, and dealing with it by way of contract.
Turning now to the creation of IP, it's very important people follow certain sort of common sense type rules. First off, actually, before you go and create any IP yourself, there may be needs to do certain searches or due diligence to make sure that you're not treading on someone else's toes in terms of IP and opening yourself up to an infringement claim, where another party can claim damages from you or even maybe seek a court order, an injunction stopping you doing it. So depending on what your line of business is, for example, you may want to search Companies House in relation to company names, just to make sure that a name that you're trying to take out isn't already taken, or actually is very similar to an existing name. I think Companies House don't always actually police that for you, so it's always possible that Companies House allows you to register a name, but the owner of another company might later come along and say, actually, it's too close to mine. And there are rules in place that whereby existing companies can actually stop new companies or force them to change their names if it's seen as being too close, too similar to theirs. If you're dealing in patents, you may well want to carry out certain patent searches. Patent searches are very important because obviously you don't really want to inadvertently infringe someone else's patent, because A, you may be sued for damages, B, you may have to stop your own project at a lot of cost of money. Also, the patent searches, if they're carried out correctly, may well show you areas where you are free to innovate or to try to register patents, and also may give you indications of previous patents that have expired, because patents typically only last 20 years from the date of filing. So there may actually be some technology out there which is disclosed through an old patent that you might be able to use yourself. Turning to creation itself, employees. If you are running a business, a company, and you have full-time employees, you don't need to worry too much about IP created by employees, because as long as they're producing the IP as part of their job, in the course of employment is usually the legal phrase, then all the IP will belong to you, the company, the employer, unless something else is set out in writing between you, and that's, I think, hardly ever going to happen. It's still good practice to have intellectual property terms set out in an employment contract, making it quite clear that all IP created in the course of employment belongs to the company and not the individual employee. And that also goes hand in hand with confidentiality clauses after someone maybe leaves the company, and potentially also non-compete or non-dealing clauses trying to stop the employee competing directly for a reasonable period after their employment. When it comes to consultants, however, i.e. any third party that you ask to produce IP for you, i.e. not an employee of yours, generally the consultant, as the creator of the IP, will own it, not you, even if you're paying them to create it. So it's very important in any agreement you have with a third-party consultant that there is a clear clauses making it clear that the intellectual property being created is owned by you, the commissioning party, not by the consultant. Otherwise, the law is probably going to say you have some form of license because you've paid money to use it, but you don't actually own it. So that could mean you own it, but you just have a non-exclusive right to use the IP, and the consultant can go off and actually license it to other people as well at the same time, which in many cases isn't going to be the object at all. There's one exception there, and that's in the area of design rights. I'm not quite sure why, but because of UK statutes, when it comes to design rights, the commissioning party, unless the contrary is agreed, will own the IP in the design rights, not the actual party creating it. One thing in terms of creation of IP that's often caused practical problems, and it's sometimes an issue that only crops up if the founding director shareholders part ways acrimoniously, or when it comes to a possible sale of the business. And that's founders, directors who already have created IP and bring the IP into a business. It's not always clear or clearly documented at the outset whether that IP was obviously created by an individual director, say, or by an individual before they were part of the company. Is that IP being owned by the company, or does it still belong in some way to the individual? And problems arise because obviously directors may or may not be employees. That's a sort of a factual test. And so sometimes directors will be, sometimes they won't be. But also if IP is created before a company is founded, unless there's a clear documentary chain, it may be debatable as to whether the company actually owns the IP or whether it's licensing it from that, say founding director. So the key thing is to always be clear and have documents in place making it quite clear as to whether IP is owned by a founder director coming in or by the company. And if it's to be by the company, there should be a formal document called an assignment, basically transferring the IP rights to the company. I do want to say a few words about protecting confidential information, because it's one of the areas that certainly businesses and clients that have come to us sometimes haven't done very well. It's important to deal with confidential information because traditional IP rules don't actually protect it. So pure ideas, business secrets, patents, designs, copyright don't really protect those. So it's important to use a non-disclosure agreement, an NDA, to do that. Key provisions of an NDA typically include describing the confidential information being disclosed. It should set out clearly the restrictions. Normally it would be that confidential information can't be used by the recipient for any reason other than a specified purpose, and it certainly can't be passed on to any third parties unless the disclosing party agrees to that in writing. There may be exceptions, I suppose, where there's a business transaction and confidential information needs to be shared with the recipient, but also, say, professional advisors, accountants, solicitors, something like that. not always present in agreements that we've seen, but it's probably quite a good idea if you can to have a clause in which says there are no warranties in relation to the accuracy or completeness of the information that you've disclosed. A warranty is just the legal fancy word really for a contractual promise. So the no warranty clause basically says, we're giving you this information in good faith, but please don't, we're not legally liable for any inaccuracies or if there's any incompleteness in it. It basically puts the onus on the recipient to actually check out the information and make sure it's happy with it, before it goes on to enter any further agreement or transaction. Also important, of course, is that depending on what the purpose is, that the disclosing party can, on reasonable notice or on certain events that can be specified, request the return or destruction of the confidential information that's been disclosed. And if the disclosing party actually opts for destruction by the recipient, usually it will back that up by asking the managing director or some other high executive of the recipient to actually write a letter signing that that's happened, to obviously bring across the seriousness of making sure that everything has been destroyed. Even if you have disclosed confidential information without a formal confidential agreement in place, because sometimes other parties refuse point blank to do it as a principle, don't despair. There are still things you can do to try to protect your confidential information. First of all, confidentiality can be, the courts have often said, can be implied from circumstances. So in fact, in most disclosures of sensitive information in a business context, where it's clear that you're not really giving it to the other party to do what they like with it, confidentiality may well be implied. But of course, it's far better to have a written agreement in black and white than having to argue that something's implied, because the court may disagree. Even if you don't have an agreement in place, either before you disclose, and preferably before and afterwards, you should tell the other side it's confidential and that they're not to use it except for a particular purpose. And always a good idea not just to say that verbally, if it's face-to-face or by telephone, but to actually send an email as well, both before and afterwards, so you start to set up an evidential chain that you certainly regard as confidential. So if they do go off and try and use it on their own without further recourse to you, you have some grounds for complaining or taking legal action. And also, if the confidential information is actually embedded, or it's going to be disclosed in the form of documentation, there's nothing to stop you, of course, putting a box or some sort of a clear statement, legend, at some point in the document stating that this is confidential information belonging to you, your company, and that it's disclosed, under confidence. The other party doesn't need to sign that. They'll obviously receive that with the document, and again, it sets up, if there was ever a dispute later on, it clearly sets up that you regard it as confidential. And there's really an onus on the other party to almost deny it straight away when they receive the document, which is unlikely, I think, in practice. Maybe a good way of illustrating how confidential information is sometimes argued in the courts is the Ministry of Sound decision that took place a few years ago. The actual case was called De Mortley and Palumbo. Interesting case in that it arose out of a group of friends who were discussing ideas for an industrial scale nightclub, discotheque type thing, which ultimately some of them went on to do, and it became the Ministry of Sound. There was a dinner at one of the friends' house one evening, and some of the initial discussions and ideas were raised. Now, one of the people at the dinner, who was one of the friends originally, was actually sort of kicked out by the others for being too difficult, and so he wasn't actually allowed to take part in the company once it was formed. He was a bit miffed at that, and he later brought a claim on the grounds that all the discussions, or part of the discussions, included ideas from him, which was confidential information. The others had sort of taken advantage of that, and he argued that part of the Ministry of Sound profits should go to him, A, as a partner, and B, because they'd used his confidential information. The court heard this. It wasn't settled. It went all the way to court. The court rejected the arguments by the claimants in relation to confidential information, and it's interesting, they did it on a number of grounds. First of all, they said, well, these were discussed over dinner in a social type setting. We're not going to imply confidentiality in those circumstances. So it needs to be in a sort of serious business context. The other main area that they found against the claimant was that the ideas disclosed at that point were quite rudimentary, very general, very vague. And I think when there was analysis of the sorts of ideas that were being discussed that night and the final Ministry of Sound concept, there wasn't really much of a direct correlation between the two. So the court said even if confidentiality could be implied in the circumstances, in fact here the confidential information wasn't sufficiently workable in a commercial meaning to qualify for protection. So the confidential information does need to be more than, it does need to have some element of originality, and it needs to be sufficiently developed that a business can actually make use of it. Very vague, nebulous ideas are not going to count. I've covered the creation of IP and also how you sort of protect confidential information. I wanted to spend a couple of minutes actually talking about how you can usefully and profitably exploit the intellectual property as well. Now, there are two main ways of doing that, I suppose, of course. One is to actually sell the IP rights outright. And the second thing with IP rights is actually more common, which is usually to license them. When it comes to a sale outright, there's usually an agreement there should be an agreement governing that, and normally, of course, the buyer is seeking warranties to the effect that the IP you're selling you own, and that there's an indemnity in case the IP has infringed any other party's rights prior to the sale to the buyer. Normally, though, IP is sold together with a business. It's part and parcel of the underlying business, and I'll come on to sort of buying and selling a business in my next slides. In relation to licensing IP, the key advantages of this are that through licensing you can divide up the rights to the underlying IP by territory, by business sectors, industry sectors, and also the actual rights that the license provides. So with one piece of IP, you can certainly maximize the revenue stream and profits if you're clever about the way in which you license. So some of the key issues as set out on the slide. First of all, if you're licensing, first of all, a license is really just a legal word for permission for someone to do something, which otherwise, of course, would be a breach of your IP rights if you're the owner. So first off, should the license be exclusive or non-exclusive? Exclusive would mean that the licensee, the party you're giving permission to use your IP, would be the only party that could use that IP. And that would actually mean that you, the owner, couldn't use the IP within the scope of that particular exclusive license. So licenses, I suppose, could be exclusive, where only the licensee can use it. Non-exclusive, where you, the owner, can license, tens, thousands, millions of users. For example, Microsoft software, non-exclusive license. Or, not mentioned on the slide, but it could be a sole, S-O-L-E license, whereby you're basically saying, I own this IP, I'm licensing you, Mr. Smith, to use it in a particular area, as set out in the license, but I also, as the owner, retain the right to do so. So that's a sole license. When it comes to exclusive licenses, you do need to be careful, though, because exclusivity means that, obviously, that by definition, no one else can use that IP. So usually, exclusive licenses, there will be either a very high license fee, or there may well be some target revenue figures as well, along the, on the basis that if you're entrusting someone with exclusivity, but they're not using the IP very effectively, and so either your royalties or the money you're getting from it isn't successful, you may want to either terminate that license because it's just not being very commercially successful, or what often happens is you may want the right to convert what is exclusive license into a non-exclusive one if certain targets aren't met. So sometimes you will have agreements, which is quite typical, whereby there'll be a target revenue or royalty, and to the extent that the exclusive licensee doesn't hit that, it either has a choice of making it up in a lump sum payment to you, so you hit so you get the minimum, or you have the right to convert their license into non-exclusive, which means you can then go and license it to other parties as well. Definition of territory, market rights, etc. I mentioned before, licensing is a very useful way of trying to, or being able to maximize the value you get out of your IP, because of course you can give one person the right to use IP in the UK, another in France, another in Spain, etc. Or, in relation to IP, you can have a wider territory or even a worldwide license, but the actual market, the actual sector in which they're allowed to use it might be aerospace only, might be healthcare, might be engineering, or what have you. You can split it up that way. Duration of the license, again, the longer the license, the risk is if it's not proving profitable to you, you might want the right to terminate it. So again, if there aren't any formal targets in place which allow you to terminate or change the type of license, better to go for a reasonably short period rather than a long one. or even have a longer period but giving you or either party the right, say, to end the license after a certain point of time. You can also have, I suppose, an indefinite license whereby license goes on indefinitely, but either you or both parties have the right to terminate on X months notice or what have you. And the other points on the slide I think I've largely covered in that recent discussion as well. When it comes to license fees, again, it's entirely really more a commercial matter between the parties as to whether, as used to be the case in more traditional software licenses, you'd pay a license fee at the outset annually. These days it may be quarterly, or with sort of SaaS, SAS models, it's more a question of paying as you go along. So it can be sort of regular quarterly, monthly, annual payments. Or some IP licenses may well be on a royalty basis, i.e. a percentage of the net profits made by the licensee. Again, if you're going on a royalty basis, consider what happens if the royalty returns are lower than you expect. Again, is there a minimum base below which you don't want to go? So it may be a royalty of X% of net profits, but in any year, the total royalty cannot be less than X. And if it is less than X and the licensee doesn't pay you the difference, then you have the right to terminate. Finally, in relation to exploiting IP, if you are licensing IP to a third party, it is quite normal for them to come and ask you or to have a written indemnity in place. The indemnity basically means that as you are the owner of the IP, if any party comes along to the licensee and says, oh, you're using this IP, we think it's infringing ours, the licensee has basically the right to turn to you, the licensor, and you have to deal with either settlement negotiations or any court case. And the indemnity will probably also say, to the extent they suffer damages against them, you as the owner of the IP have to meet that. So indemnities can be a little scary in that there may not be a cap, in theory, on what you may have to pay the licensee. In some cases, it may be possible to negotiate a cap on the indemnity, so it's an indemnity.
But in those circumstances, for example, will licensor's exposure be more than X thousand or million pounds?
Okay, on the last leg of today's webinar in relation to IP, and I wanted to touch on sale of a business which contains IP, because it's one of the most common sort of questions or issues that obviously business owners come to us with, and it also helps to maybe put a bit of sort of practical light on IP and what you can do to try and protect it, and again maximize the value. So on any sale of a business, and sale of a business in containing IP is no difference, there is a due diligence exercise. Why carry it out? Well, in essence, really, the due diligence exercise is for the benefit of the buyer, because the buyer wants to make sure it's spending its money wisely and it's getting what it thinks it does get, particularly if it's buying a business as a going concern. So in particular, sort of looking at things with an IP hat on, key points of the sale process in relation to IP businesses will include certain pre-acquisition inquiries from the buyer, asking for information effectively. When it comes to the sale agreement, the buyer would also expect certain IP warranties to be put in place, certain promises, contractual promises given by the seller in relation to IP matters. There is also at some stage going to be something called a disclosure letter. A disclosure letter is the ability of the seller to put certain matters in the letter, which basically are disclosing factual matters to the buyer. And the aim of that is, to the extent things have been set out in the disclosure letter, they can't be the subject of a warranty claim later on. So the warranties are promises which basically give a buyer the right to claim damages later if those contractual promises are false, but that's qualified by a disclosure letter which basically deems knowledge on the part of the buyer of certain matters, and again, in most cases, the result of that will be there can't be a claim for matters that set out in the disclosure letter. So if there are any imperfections or problems with IP, if they can't be resolved by agreements, assignments, they should be set out in the disclosure letter to protect you as the seller. As I mentioned, IP warranties are really just promises trying to protect the buyer. Disclosure letter will be limiting those warranties. When it comes to selling a business, of course, the seller needs to tie up all the loose ends on IP issues, and ideally, of course, they'll have been tied up well before the sale process starts. And in an ideal world, which of course hardly ever exists, IP matters will have been tidied up or dealt with properly as you go along. So there isn't
like a mad rush to put things right just before you sell the business.
Moving on to the specific IP warranties that a seller will often be asked to give by a buyer. I've set them out on this slide. They're relatively factual, relatively sort of straightforward types of things when you actually think about what the buyer is looking for. I'll only highlight one or two of them. Of course, one of the warranties will be sort of complete lists or tables setting out what the IP is that you own. In particular, usually it's split up into registered rights, unregistered rights. Also, buyers are very concerned to find out what IP are you licensing in from other parties. In particular, although we've been concentrating on IP that the business itself owns, your business on a day-to-day basis may be dependent on IP that you license in from other parties. So the buyer wants to make sure that those license agreements are in place and that they won't stop after the sale, so they'll stay in place and the business is going to be able to run smoothly. Details of IP licensed out to third parties, just for knowing what the general position is, buyers want to know that. Also in relation to whether there's been any claims in relation to your IP infringing third parties, and if there are claims or litigation, what stage they've reached, and also whether there's been any instances of infringement of your IP rights by others. Generally, and sometimes there's a lot of negotiation as to exactly how detailed these warranties are, that can take quite a lot of time, but often buyers will also ask for some sort of a general warranty that your business has the right to use all the IP it needs to carry on the business. And again, depending on the bargaining strength of the parties, that can be either narrowed down, which is the benefit of the seller, or more nebulous, wider, which is probably in the interests of the buyer. So I've given a quick overview as to what the sale of a business process is in quite a simplistic way, and obviously how it tends to apply in terms of key warranties in relation to IP matters. It's probably worth spending a couple of minutes on really getting your IP house in order, and as you'll see there are points on this slide. In particular, it goes without saying, as far as you can, you should try to anticipate what the buyer's due diligence or pre-acquisition inquiries will be, so that you can meet those before the actual buyer comes along and asks them of you. It also gives you opportunity to perfect any areas where, for example, there isn't a clear contractual chain of IP ownership or licenses that you need in place and you can't quite find formal licenses to that effect. So do collate all information that you have on IP, and particularly the IP that you own or are using. Are all the key licensing agreements on which you rely or on which you're licensing out your IP clearly in writing? If not, do put them in writing. Also, if any key agreements need to be renewed or extended, try to do that before the sale. In particular, one thing which often catches people out or can cause an issue is if you are reliant on a supply of IP or any other matter for that reason, if there is a change of control provision, you might need to look at that carefully and maybe try to renegotiate that, because a change of control provision means that the other party to this agreement has the ability to terminate if the control of the company changes. So of course, if you're proposing to sell your business, in most cases that will be basically just a sale of the shares from the existing shareholders to the new shareholders. So that is obviously very much a change of control. So if there's any key strategic licensing agreements in place that have that, you're in a very vulnerable position in that the other party can actually terminate the agreement. Again, if the day-to-day running of the business is dependent on those agreements, the risk of having those agreements terminated just after the new owners come in could either kibosh the whole deal or reduce the price significantly. So do try and check for change of control provisions, because they can be hidden, not easy to spot, but they can undermine the value of your business. I've mentioned on IP ownership, making sure there's a clear chain that the company owns the rights, i.e. all employment contracts in place. If you've used third-party consultants, can you show that all IP created is clearly owned by you? There are express terms to that effect. If there are any gaps or problems, as mentioned previously, that you can't easily resolve, then you really must refer to them in the disclosure letter, and or take out specific insurance against them in case there is a future claim or dispute because of them. The final slide really for today is really just a summary of, from our experience, some of the top IP tips that we can give to you. First of all, I mentioned it before, but you can't prepare too early for due diligence or getting your IP ready for a possible sale of the business. In some cases, actually, it may actually not be possible to rectify it, at the 11th hour, just before you sell, and it could actually, ruin the whole chances of selling the business, or certainly significantly undermine the value of the business. So prepare early. Do educate your personnel on the value and the importance of IP. We've certainly come across instances where certain clients, big clients, have got different departments. They don't always communicate very well, and sometimes technical advances in one department, which potentially were patentable and could have had, commercial value, were seen by certain individuals as not being terribly important because they didn't really fully understand the workings of other parts of the business. And so opportunities to actually take up patents to increase the value of the IP were lost. Do carry out IP searches as early as possible before you start either creating names for companies, or certainly if it comes to patents, you need to make sure you know what's out there in the particular field you'll be carrying out research or innovation in, because there may well be patents out there which you will be infringing. Or, as I mentioned previously, there may even be some lapsed patents that have actually expired, which you can make use of as well and help you with your research. Identify and record all items of IP that you have. Do keep an up-to-date record. That's important. And as I say, do have express terms on creation of IP ownership whenever you're having IP created by outside third parties. Co-ownership of IP rights can occur. IP is a form of property, so you can have co-owners. It is best avoided if you can, because there are a number of complications. For example, in patents, co-owners can go off and exploit the patents they co-own without recourse to the other party, without the other party's consent. But if it comes to granting a license to a third party or even selling the patents, you need the consent and agreement of other parties. So co-ownership of IP rights can be problematic in that you, as one of two or more owners, you don't have full rights. You are partly dependent on what other co-owners want to do, which may well limit your scope of manoeuvre. Finally, having a proper licensing strategy in part. I suppose that's part of the last point too, having an IP strategy in place. But if you work out your market correctly, using licensing effectively means that you'll be able to potentially split the rights that you have by sectors, by geography, and by functions to maximize the revenues you get from a particular piece of IP. And as I mentioned previously, an IP strategy should only be part of the wider business plan, and the IP strategy needs to fit in with the business plan, not the other way around. Thanks very much, and I think I will be having a quick discussion and a couple of questions from Soraya.
We will, yeah. Great, well listen John, thank you very much for that. It was absolutely fantastic. I can see an awful lot of information that goes into this. It can be a very complex subject, really, isn't it? Thus,
can be.
Be around if it wasn't,
yeah,
would you?
That's true.
Good stuff. Okay. Well, look, we have quite a number of questions here, so please do bear with us. And again, if you have ones that aren't answered here, do email them over to us, and we will get them answered. We might be able to do a Q&A if we get a lot of them down the line. If that's okay with you, John.
Yeah, that's fine, Sarah. Yeah.
Super. Okay. So just based on the questions that have been sent so far, first one I have here is, what are the most common pitfalls when creating IP?
The most common pitfalls, I think I've touched on those to some extent already. One is that, people have IP created by people outside their organisation, i.e. consultants, third parties, and they don't always have the fact that the IP will be owned by them once they pay for it. And in the absence of that, then they have a license rather than actual outright ownership of the IP. There are a number of cases sometimes whereby, and depending on the factual situation, it's sometimes just possible to argue that in all the circumstances and given the amount of money, particularly if it's high, that you actually have an exclusive license, or even that the parties themselves, there should be an implied term that you own the IP, even though the agreement doesn't say it. The trouble is the courts in recent years have been reluctant to imply terms into contracts, because they'll say, look, the parties put the contract in, that clause could have gone in, it didn't, so we can only presume, we're as the judges, we're not here to rewrite your contract, we're here to interpret it. And implied terms, which is a separate area, but the courts these days are trying to say, unless you need that implied term to make the contract actually work, we're not going to add it, I'm afraid. So, i.e., you need to get the contractual points right to begin with.
Okay, so being very precise with what
Yeah,
the
yeah.
wording of it, very precise.
Oh, yeah, it doesn't have to be, it's not any particular form of wording. The clear thing is that all IP rights, in relation to the particular contract, the work product, the materials, belong to you.
Okay.
Obviously subject to payment.
Fair enough.
If you're the party creating the IP, that sort of clause is fine, but you always want to make sure that IP isn't transferred on creation, which I've seen in some agreements. If you're the party creating IP, you want to make sure that, IP transfers, but only once, you've been paid in full.
Okay. All right. Well, that makes sense. It does. Okay. Next question we have here is, what are the key dangers in licensing?
Licensing. In a commercial sense, the key dangers from a licensor's point of view are probably sort of similar. Two key things. I mentioned one of them already. Granting exclusive licenses, be very wary about doing that, because if it's exclusivity, you need to have safeguards in place. So if it doesn't go as well as you think, you can get out of that quite quickly. The last thing you want is an exclusive license for a potentially valuable piece of IP to another party that for some reason or another either can't market it very well or doesn't. And you can't get out of the agreement either by termination or by converting it to a non-exclusive license.
So do you need to put that sort of a clause in it then?
Yeah, I mean, if you can, try and make it non-exclusive rather than exclusive. Or if it's exclusive, can you segment it so that it's in terms of some IP, or it's only exclusive in certain territories, not worldwide, or is it only exclusive worldwide but only for some industry sectors?
Right.
So that other parties, you can free to license to other parties, either not in that territory, not in that industry sector.
So basically, give yourself as much freedom as you can,
Yeah.
and be very clear again in what you write down. So,
Yes, yes.
Okay,
And as I've said already, I think if it's exclusive, then you need to make sure you should seriously consider having either a higher royalty or having sort of minimum targets in terms of license fees, or just an underlying high license fee.
Okay, so
Which
understand what you want out of it.
Yeah.
Okay.
Commercially, yeah.
Yeah, okay, all right. Very good. Makes sense. Okay, so, let's talk a little bit about the costs of it here. A question that came in.
One thing, just going back to license, I was
Yeah.
just thinking, that's from the licensor's point of view. From a licensee's point of view, and we have it with the current client, they have an exclusive license, effectively worldwide, to sell a particular software product, which is good for them, not so good for the licensor. But where they have a very vulnerable contract is that if there's any change of control of the licensees, our clients, to sister companies, the licensor has the right to terminate the agreement. So that this change of control provision means, and the way it's actually drafted is even worse, because it means if at the moment, if someone wants to come in and buy their company, then the licensor could terminate the agreement. And the business only really has a value if the licenses are in place.
Oh my God.
But the other thing is, the way it's actually written, if one of the three shareholders were to die, that's a change. That it looks on the wording of it. That would mean actually that.
So it sounds like they didn't reuse the contract too closely, or just didn't anticipate
Well,
what would
but
happen in the future.
in the real world, of course, this is a situation whereby the licensor and the licensees used to work together, and the licensor, I think, did a law degree but wasn't a professional lawyer, but he used to do the agreements for them and for his own business. And when it came to this license, he did the drafting and they signed it without taking external advice.
Okay.
So
take external advice.
on things like that, yeah.
Well, because that is just like a catch-22. You can't win with that one, can you?
Yeah, so that's one of those things that we're just trying to choose the right time to go back to the licensor to try to negotiate some amendments. And it may well be that to get that change of control modified or removed, we might need to increase the royalty he's getting.
Okay.
But longer term, I think for them it makes sense.
It sounds like you have a path forward with it anyway. But God almighty, what a nightmare.
Not good.
Not good, no, okay. Well, look, the question has come up here on cost. So, I know it's how long is a piece of string here, because a patent can cost an enormous amount depending on where in the world you're registering it and so on. But a lot of questions that people get asked, we get asked, and the question got asked here, is about software code. Because obviously most people, when they put their software online, it's global already. So, how much would it cost, or what would a person have to spend to protect the software code?
Well, in relation to software code, most software is protected by copyright rather than patents. And as I mentioned previously, copyright arises automatically, so there's no registration in most countries for copyright. So if you're the company producing the copyright, you will be the copyright owner. So you own that free.
Right.
Now, some software, if it has a technical effect on hardware, may also be patentable. I mean, patentability of software is a huge subject in itself, and it's very hard to explain in a few words. But most software, I'm assuming for argument's sake, is protected by copyright, not patents. A small element of software, not the software itself, but because it has a direct effect on hardware, can be patentable. And patents, certainly within the UK, a rough rule of thumb I've heard from patent attorneys is that, the early stages can be up to £5,000, and from the early stages to registration can be something similar. It can be a little bit less, and in some cases can be quite a bit more. So patents are not cheap. They're not cheap, but they're a very valuable right if you get them, because you have a monopoly, and you have a monopoly that lasts for 20 years. For other rights, we for example, do register straightforward trademarks. A UK trademark in one class is going to cost you about, if we handled it for you, you're probably talking about £750, £800. That's assuming it's straightforward, and by straightforward I mean, like all registration processes for IP, there comes a point when obviously you apply for a trademark, it gets published, and the trademark office basically invites third parties to challenge it on the basis that it's too close to an existing trademark. Assuming there isn't that, which turns out into mini litigation, £750, £800 plus VAT will get you a UK trademark, and you can usually get that within 6 months.
Too bad.
No, it's not.
6 months?
Yeah, it's very quick. UK is pretty quick. For a community-wide trademark, all the EU countries, again, if it's a straightforward one with not objections from other parties, you'll get a community trademark for those 20-odd countries for about £2,000.
Okay. Not too bad again. Not too bad.
Much cheaper than patents, yeah.
Much cheaper than patents, right? Yeah, absolutely. Okay. Well, I guess that kind of ties in with the next question here. So
the good thing about trademarks too is that they are, once you've got it and you paid your registration fees, you get that for 10 years. And as long as you pay the renewal fee, the trademark, as long as it's not revoked or someone challenges it successfully, that can go on indefinitely.
Definitely.
Yeah.
Okay. All right. Also good to know. Time is involved in that. Okay. So just what you were talking about with the cost, it relates to another question that we got asked here, was like, what do you do if the employee is trying to take your IP? But you did already answer that earlier when you were saying, that if they are an employee, that it already belongs to the company. That the problem is if they're a consultant, that's the problem there.
Employees should be, employees producing IP, the IP will be owned by the company. So if the employee tries to use it on its own benefit or leaves the company and tries to use it, then that's sort of tantamount to theft as well as copyright infringement.
Right, okay. But it ties back to, I guess, software code a lot, because a lot of people would do they would use like a consultant or someone doing a gig to write some of the software, so you have to be very careful for putting a contract there for them, obviously. Otherwise, the software code could belong to them.
The consultant?
Yes.
Yes, you need clear terms expressing that the IP will be owned by the company that's commissioned the consultant.
Right, so very clear.
Yeah.
Okay, good to know, because I know a lot of people feel like they meet somebody over a coffee and say, oh yeah, you seem like you can do the job, and then that's the extent.
Yeah, the agreements don't need to be terribly long, and there's no specific form of wording you need to use. Just making it just clear in normal English that the IP in the copyright or whatever it is in the software belongs to you once you've paid for it.
Good advice, and easy to set up. Free to put the clause in at the beginning, right? Exactly. Okay, so another question we got here is, how do you check what papers are already out there?
Well, there's a certain amount. The Intellectual Property Office, which I think is www.ipo.gov, has a lot of information, both on creating IP, so registering IP, trademarks, patents, designs. They also have very easy online search facilities, so although it's not 100% accurate, but for most normal purposes, a mixture of internet and the trademark part of the IPO website, if you put in a word or a logo, you'll get results on similar or identical trademarks.
That's usually just be in the UK, or
that covers UK and European trademarks.
Okay.
Same thing with patents, although patents by their nature are not quite as easy as to understand for a layperson, I think, as a trademark, which is just a word, a word or a logo. There are some specialist, patent trademark attorneys can carry out more in-depth searches. If we're talking about high-value matters, because as I say, the online trademark searches at the IPO for most people are probably good enough. But again, if you're putting a lot of money into a big launch, you might want to actually have a more in-depth trademark search carried out. And the same thing for patents,
Right.
because they're more complicated.
Okay. Yes, and basically you need to be an engineer to understand some of these things.
So yeah, what's potentially infringing another one is a specialist area.
Right.
We would call in people to do that because we're not competent to check rival patents.
Right. Well, so not surprising. There's a huge world of industry out there, really, isn't there? Okay, well, just leading on from that one. What if you have a company name and another company has the same name, but they're in a different industry? Is that okay?
Well, if you talk about there shouldn't be the same name a company's house. Say, if it's a formal limited company, company's house will, off their own back, stop you having an identical name because that's on the register on the company's house you can't have identical names.
Yeah.
If someone's already got one, you can't have the same. And also, of course, if it's seen as being confusingly similar, they'll probably stop you as well. You've probably seen, if you ever look down the list of companies, you'll see very small variations between companies. As I say, company's house to some extent will stop obviously misleading or confusingly similar ones. Otherwise, it's up to the parties themselves. So just the fact that you put a name into company's house which is accepted or company's registry doesn't mean that's a foolproof guarantee that no one can challenge it afterwards.
Right. And what about people, for instance, because I've seen this before with food companies where they just come up with a name and they're maybe just doing some street trading and they didn't expect it to get very big, but suddenly it did. And then they find out that somebody else is using the same name for a similar product in a different area. We've certainly had that one before. Would the fact that you've been using the name first count for anything if you could prove it, or does that make any difference whatsoever?
It would depend on the specific circumstances, but if someone's got a registered trademark, if you could show you'd been using, in good faith, that mark before they had a registered trademark, yes, I think you get limited. There's a limited scope for defence. But otherwise, if you have a trademark and someone else is using it for similar class of goods or services within the same territory, i.e. we're talking about the UK now, I think, then it would be infringement on the face of it.
Okay.
One thing I didn't mention earlier on, but on trademarks, you get trademarks, there's 40, 50 classes dividing up marks between different types of good and different types of service, and they're all numbered. So people have trademarks in usually 1, 2, 3, maybe 4 or even more classes. So similar names in completely different classes of goods and service, there's probably not going to be infringement. So again, that if they're different, because they're not competing, because they're in different business areas.
Right.
But if they're in the same areas, then there is likely to be infringement.
Okay. All right. Well, that kind of makes sense, I guess, as well. But we've seen that one come up before as well with the people. We had one guy who had to change his name because he wasn't there first.
No, that's right. And that can be expensive. So
yeah.
It's not so much always the damages that someone can get against you. It's the fact that you have to change your stationery, change your typeface, change your name. That's, disruptive to the business and it does cost. So it has a cost itself.
It does. I agree. That's what we saw as well. Okay, so another question we have here is, how do you actually enforce a patent or IP?
Well, intellectual property, like any other legal right, I suppose, is enforced ultimately through legal action. Normally what will happen is the first stage will be either the company itself becomes aware of a possible infringement and they'll either write an initial letter to the other party, or they should do, asking them, setting out what they believe is going on and why they think it's an infringement, and asking the other party to desist. And if they don't, then the next stage obviously is go to a lawyer who will write a slightly more aggressive letter, I guess. Sometimes, if it's slightly technical and things, the clients will be aware of certain factual background, they'll come to us and we will write what's commonly called a letter for action. So it's a letter setting out what our client owns, what we think the other party is doing, and give brief reasons as to why we think they're infringing our client's IP rights. And if they don't stop, then of course the client has the option of either starting formal legal action, dropping it, or maybe trying a sort of a halfway house, may well be mediation. Sometimes on IP there can be overlapping uses of IP, but neither party wants the hassle or the cost of litigating. So certainly in trademarks there are things called coexistence agreements, whereby parties that otherwise might have trademarks which are overlapping each other agree that they'll only use these trademarks in particular areas or in particular ways, which if they stick to that, the other party is happy that it's not going to infringe on their business activity too much.
Right, on their territory, so to speak.
Yeah, yeah.
Okay, all right. And I guess because there are so many companies opening up, I mean, 600,000 a year are starting up in the UK at the moment, it's very likely that you're going to have a lot of similar names and similar trademarks. You know, I can see that coming up.
What, through force of numbers? I suppose so. But if the onus is still on people setting up to have done their checks. Yeah. So it's no defence to be. Ignorance is no defence. Right. The fact it wasn't deliberate infringement, it's either infringement or it's not in terms of trademark name set.
That's good. Do the checks.
Yeah.
Okay. So another question getting here about websites. So most people outsource the building of their website to somebody else. Who owns the IP on that?
Well, the website designer will, in theory, own the design because copyright is owned by the creator. So that's the starting point. I would hope that in any well-drafted website design agreement, there's going to be a clause stating that the website design company will transfer ownership in the IP to its client, once obviously payment's been received in full.
Okay. So basically check the agreement to make sure that that's
you need clear ownership terms, making it clear that the client owns it.
Right. Okay, so check for that.
Yeah.
Okay, very good. Okay. And the question here is, are there templates out there for IP that people can copy? And if there are, such like a Google search or whatever, are they trustworthy in your opinion?
There are a lot of precedents, a lot of agreements that you can download from the internet, and their quality varies quite a bit. Some are not bad at all, quite a few though are sort of quite terrible. And some clients have tried to cut and paste and get away with it to obviously save money on legal fees and things, and you can understand why in early days when obviously money's a little bit tight in that. You need to be very careful though, because as I say, some of our clients, the more intelligent ones or guys who've drafted contracts can do quite a good job. Quite a few clients though have cobbled together things that are not very good at all.
Right.
Not very good at all.
Did you spend a lot of time editing badly worded contracts?
It does happen sometimes. It does happen, but there comes a point, of course, when people say, well, this is what we've been using, we put it together ourselves, blah, 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 or through a friend as a favour. And on a cost basis as well as a practical basis, it's often quicker for us to use our own existing agreements, and we also have our own templates too that we tailor for clients, but they start off from a much better position. Right. But it's often quicker and easier to do that than it is to try to go through a contract where you're changing some things, not others, and then sometimes the internal clauses and definitions won't hang together. Right. So, if it's badly drafted, it's often quicker and cheaper to start from scratch.
Okay, so basically if you're going to copy from the internet, get an IP lawyer to look over it first, and then you'll probably end up using their template anyway.
Quite likely, yeah, quite likely,
okay.
Right.
Okay, fair enough. Okay, I understand. But it's better to do it that way than get yourself into hot water down the line. People think that they're taking a shortcut, but in actual fact, it can be very costly.
It can. There's always a cost-benefit thing. These days, although lawyers have a reputation of being quite expensive, for relatively straightforward commercial agreements and including IP, so reviewing web design agreements or putting them together, usually these days, because we've done quite a few of them, we know a rough parameter what the cost will be. So unless it's really doing something bespoke from scratch, which usually isn't the case, we can either usually give either a fixed price or it's going to be between X and Y. Okay. And in practice, it's very hard for us to charge more than Y unless things have changed along the way.
Okay. All right. So people know at the outset.
Yeah.
Okay. Well, that's good. Now I have a question. I think you've already answered it, but the question was about anybody going for sort of like angel funding or going for sort of crowdfunding, that they've had people who won't sign NDAs, like angels who won't sign NDAs for that, which I can understand why not. But with that, what you basically said is that as long as that is written in the paperwork that this is a confidential agreement, that it's okay that they don't sign an NDA. Did I think that right?
Well, yeah, I was making the point that even if you don't have an NDA in place, You don't have to throw your hands up in the air and think, well, I can't do anything. As I say, if you're actually disclosing a document that contains some of the confidential stuff that you're disclosing, you can have a box, a prominent box somewhere or statement to the effect that it's confidential information belonging to you, your organisation, and it's disclosed under confidence. And even if you don't have it, even if you've sent a document across which doesn't have that sort of a box or legend in it, you can, as I say, prepare the ground by discussing verbally and also by an email that what you're sending is confidential and is only to be used for the purpose of the discussion that you're having. And so, ideally, both before, an email or letter before, and after you've actually disclosed it, just to bring the... Yeah. Okay. So, the recipient may not, you can't actually force them to sign something, but you can at least set up, so if ever there was an issue and you think someone's run off with your secrets, that there's a bit of an evidential chain, you treat it as confidential, and they're not to use it in such a way. Again, it will hopefully will be a deterrent to them, or the other party, not to try and rip off your ideas without coming back to you. Okay. The other thing is, in a practical sense, is if you don't know the other party very well, but you're disclosing certain things to them, initially, a bit like looking for investment sometimes, people send out teaser documents, so just enough information to make some sense of what it is you have without giving away the crown jewels at the outset. Okay. That may be another way too. Right.
And that would be the same, I guess, for setting a company as well. You wouldn't have
yes. Yeah, exactly.
But they will sign generally an NDA for setting a company.
Yeah, normally. Yeah. Normally.
Yeah, okay. Another question that we have here is there a basic way about going about licensing your product? I know a lot of people have a lot of questions about licensing. I mean, number one, can you do it yourself? Obviously the answer is yes, but should you? Probably not. I think you've already covered that in a different question. But what are the main headings that you would want someone to have inside the license agreement?
Hopefully I covered some of this earlier on in the presentation. But some of the key fundamentals in relation to licensing, I suppose, first of all, if you have got an IP strategy, where does licensing fit within that overall strategy? Yeah. What type of a license is it? I.e., am I granting a license to you on an exclusive basis? So just you can use that IP. Is it a sole license so that both you and I can, but no one else? Or is it a non-exclusive license? That's a key fundamental one. And depending on the market and the type of IP, you get your answer. If it's exclusive, do make sure you're not overcommitting yourself for too long, and that the revenues you're getting are good. Sometimes the revenues increase from year to year on the basis that the licensee is ramping up its business and operations. So the overall profits and any royalty payment, for example, should be going up over time. And if things aren't going as well as you would like, do you have the ability to terminate? Not just because of breach or insolvency, but because you have the right to terminate for convenience. Yeah. So A, don't tie yourself down for too long a period, and B, try and give yourself the right to terminate for convenience at regular intervals, or possibly even better, on at any time you can terminate for convenience on giving X months notice.
Okay, good advice. Okay, very good. Another question that we had in here, you talked earlier about a royalty license. Now, is that the same as like a franchisee license? Or
not really. I mean, a royalty is just one way of just one of the forms of payment under a license agreement, because the license agreement can just say you pay us a monthly or an annual fee of X, and that's it. So it's a fixed type of amount, certain. A royalty one is much more on the basis that you will pay me 10% of the net profits you're making in a year, and those profits are based on use of the IP. So the royalty one is not a fixed amount. So for me, the licensor, there's a slight risk, but it's more flexible, I suppose. So you might, in early days, you might be saying, well, I'm happy to pay you 10%, but I can't pay you a fixed £50,000 annual license fee because I'm not earning enough. So there may be commercial reasons why, for both parties, the royalty one is what I want to go for. And of course, if it's a percentage of your profits, if the profits turn out to be very high, then the percentage can be quite high as well. So it's, I suppose, royalty is more gain and more risk. If it's a small profit, then the royalty will be low. If it's a high profit, the royalty will be higher. But again, you can mitigate against the royalty being disappointing if the net profits of the licensee are low by saying, well, it's a royalty of X%, but at the same time, in any year, there is a minimum payment you must make to me, which is X or Y. Okay. And if you don't do that, I can terminate possibly, or I can make it non-exclusive.
Yeah. Well, it seems, I mean, it's the same, I think, from what I've heard the whole way through, is that really what you need to do with all of these different types of licenses and all these different types of IP and agreements is that you really need to think ahead, what will the future be, and what is it that I want out of it, and what's fair to the other party as well. You know, so it's just a question of putting yourself in a future you, and you know, what do I want to get out of this, and what is it likely to appear in the future, or what possible problems are likely to come up. There's always something that comes up that you can never foretell, but just to kind of get rid of the main ones is really about thinking clearly and then writing that down in good plain English, I suppose, because it's easy to understand and interpret.
The royalty, I mean, I discussed what a royalty was. I didn't go on to, I suppose, say what a franchise. By a franchise agreement, really, a franchise is slightly different. A franchise is essentially an agreement whereby usually one party, the franchisor, grants the franchisee certain rights to use a name, a business name, and also, so there's often a trademark license involved because it's, you know, something like Kentucky Fried Chicken or McDonald's, I think, have a franchise model in part. So that's justifies, well, they would say it justifies quite a high payment for use of the name in a particular area, and also a proportion of the profits are paid to the franchisor. In return for usually some certain marketing materials and training, but the key thing is it's usually a well-known trademark that you're getting the right to use, on the basis that in itself should bring in quite a bit of business. And for that right, you're just paying the franchisor, you know, basically like a trademark license fee, plus a sort of a set proportion of the profits that are made.
Right. Okay. And usually they're very clearly defined, particularly the bigger brands out there are not very defined.
Yes, and usually, yeah, and because they're usually very big operators, franchise agreements at that level are usually fairly one-sided, so that, you know, there's not much negotiation. If a franchisee wants to become a McDonald's franchisee or KFC franchisee, I think in practice there's very little room to negotiate the different terms.
Take it or leave it,
more or less, yeah, more or less.
Okay. Happens, right? If you're one of the big guys, you have a different power.
Bargaining power.
Exactly. Okay. So last question we have here is, how do you check for infringement on your IP? How do you know if someone's infringed it?
In many cases, you won't actually know. In some cases, certainly copyright type things, you won't always. Other than seeing, you know, competitors doing things, and then you get a bit suspicious. In relation to registered rights, it's a bit easier because you can set up trademark searches, and you can set up patent searches, which report back to you. For example, for trademarks, if you have a trademark, you'll probably put in a search for that word, so that anything similar to that word or logo coming up in, say, defined territories will be reported back to you. We acted for a very large sort of stationery provider, and they had a regular trademark search in place. It came back with a number of similar marks. 99% of the times we didn't do anything. The other few occasions we did sometimes challenge it, but even that company, which was quite big, didn't really want to get involved in litigation unless it was very much a last resort. So often we entered into coexistence agreements in one or two cases.
Okay. So there's room for negotiation depending on each
On that area there was. But for registered IP rights, patents, trademarks and designs, there are certain formal searches you can put in which report back to you on a monthly, quarterly or annual basis. For some very big organisations, because patents are expensive, usually if you've got the money to invest in the patents, you're usually the size, or patents are so important that you'll have a team regularly looking at what's being applied for in relevant patent fields.
Okay. To see if someone's made a slight
It's to see if anyone's maybe treading on your toes, and just to follow developments in that area.
So does it seem you can't rely on the fact that they might have a patent refused because it's too similar to yours? Could you rely on that, or?
Well, if the patent authorities are refusing a patent, then yes.
But you can't rely on that. I mean, if somebody, for instance, I thought there was a guy in Switzerland who Dyson hadn't patented the territory of Switzerland, and so he was able to make his own version of Dyson almost exactly, but not call it Dyson, and there was nothing that Dyson could do about that.
Well, in pure patent terms, yes, that comes back to the territorial principle, which is that most nearly all IP rights are, for registrations, you register in a particular territory. So if you register and pay your money and you've got the patent or trademark, you're covered in that territory. But in the real world, there are 200 countries now. No one really, A, can afford to protect themselves in every country, Or again, even with the Dyson one, I guess Switzerland was probably not a key market. That's why he didn't have a patent in it. Bit galling. I suppose the guy had to change his name, otherwise there would have been probably some unfair competition rule in Swiss law that they could have used.
I don't know what he called it, but I know that he was able to do it, and he made several
Yeah,
million each year from doing it.
That is a bit galling. But in terms of patents, yes, if you don't have a patent registered in a particular territory, you have no patent rights there. There might be some other local, I don't know whether Swiss law would have given some other right. It wouldn't be patent, but if they'd used a name, similar name, then there might have been some passing off or Swiss equivalent.
Right. Well, he got away with it anyway.
Yeah, well.
I certainly know there's a lot of people, for instance, who are trying to look for the latest products to bring into the UK. They'll go over to the US, go to trade shows, see what's new that's coming up, and then check to see if there's a territory agreement for the UK. If not, very often that's what they'll do. They'll just go and manufacture a version of that and just keep it for the UK. For many people doing things like that, just, I guess, taking advantage of that.
Yes, it will be.
Completely. And fair play if you have the ability to do something like that.
Yeah, I mean that point just brings back that there are limits to IP protection as well, and territoriality is one of them. Right. These rights aren't universal, so you have to, for registered IP rights, you have to go through the registration process, and as I say, that brings in cost, and so you need to manage the costs with what's key markets for you.
There we are. Very good. Well, listen, thank you very much. I'm going to the end of the questions there. Thank you so much for taking the time to chat with us. A lot of absolutely fantastic information there, and I think a lot of the questions were really quite good. There's a lot of extra stuff involved in there, so thank you very much for that. I'm guessing if you guys have questions, you can email us at either info@startuprichmond.com or just directly to you, Joe. What's your email address, John? It's on the slide anyway.
It is, yeah. It's john.warchus@moreblatch.com.